Hi, and welcome to the Law Simplified. I'm Shavin Bandardanayaka. Bear with me for this very first live stream on multiple platforms. I'm currently streaming both on the YouTube channel, on the Law Simplified channel, as well as on the Facebook page as well. So hopefully you're getting the transmission on both platforms. If you're not, I hope at least one of those two platforms are working properly. Having said that, I thought I'll start slightly earlier just to get everything set up and running. Having said that, everything as is before, and welcome to our live Q&A session on Tort Law. This is the fourth Q&A session that we are doing. In the previous few weeks, as you would recall, and you can find on this very channel as well, we went through criminal law, contract law, as well as public law. So you could consider this as being one of the first sessions where we are going over level 5 or second or third year in relation to certain LLB, GDL, and other higher education syllabuses. Thank you once again for joining me. I know that it's a very tough time, a lot of adversity for many students all around the world, which is the very reason why this series of sessions were started in the first place. Primarily because I realize the fact that most of you, while you can prepare and study for the LLB or your law degree in isolation, you need not necessarily be among others to study and prepare for your examinations. It always helps to have some sort of community built up around you so that you can bounce off ideas. On a number of occasions, I have said on this YouTube channel, on my Facebook page, as well as to my Masterclass and Fast Track students as well, that law is far less about what you know, it's much more about how you think. So it's always good to have an audience, it's always good to have people around you and a community built up in order to prepare for all law examinations. Now, having said that, this particular series of Q&As, as you might be aware, having joined the previous sessions as well, is structured in a very particular manner. The idea is it's not a thorough outline, it's not an A to Z essentially of the subject, far from it. Tort law is a very vast subject, there's a lot of case law, there's a lot of principles, most of which you can understand and learn from various resources that are provided to you by your university, as well as other resources, including the ones that are available as playlists channel, as well as my online law school platform, which you can access through the links in the description on the YouTube channel. Having said that, the way that this is specifically structured, this particular Q&A session, is on the one hand, we will be going through a fast track of the theory lessons, having a broad stroke idea and a look at what is part and parcel of this particular subject. What are we really considering when we look at tort law, the different topics, and how specifically we apply it to an examination context or even an assignment submission at that, if you are in a university or a higher education establishment that prefers that format. On the other hand, we'll spend about 15 to 20 minutes on that, and then we'll focus predominantly on the questions and answers, the Q&As that are provided by y'all who's watching this particular live stream. So you can leave comments or questions on either the live stream that's currently happening on Facebook, on the Facebook page, or as you see here indicated on screen right now, you can do so on the YouTube channel as well, on the live chat on the YouTube channel. Either way is fine, and at the very end, we will not only go through this, but there was a notification that was sent out to pretty much every subscriber out there to any other questions that they might have prior to this session as well. And there are a couple of questions that came about, so I'll go through those as well. Right, now having said that, when we go through this particular subject, there are a few nuances that we need to consider. So let's give a minute or so that we have, I already see a few concurrent viewers on both YouTube as well as Facebook. So let's give it about 60 seconds to add up a few other students and a few other viewers before we proceed. But overall, as we are going on the aspect of tort law, a good rule of thumb when preparing for this subject as well as going through this live stream as well is to keep in mind the fact that tort law is something that is vast in general, but it's not overly complicated in understanding the subject matter. I often say this to my fast track and masterclass students. The toughest thing about tort law is not the logic of it, it's not the principles, it's the volume itself. If you take all of the subjects out there in a law degree, in an LLB or an equivalent, what you would predominantly see is that there is a descending scale based on the year that you are studying your qualification in. So for example, if you take the volume in relation to the substantive law, the case law, whatever that is used to sort of buttress your arguments, all of that seems quite high, or rather high end, when it comes to subjects such as tort law, property law, the law of trust, company law, anything in the level 5 and 6 areas. But then when you come to your first years, when you've gone through, for example, subjects like criminal law or contract law or public law, by and large, what we gather and what we see is the fact that the subject matter, the principles, might seem more difficult as a student coming in because it's the first time that you are introduced to not just the subjects themselves, but the very difference in the manner in which we prepare for them. It's not like any other qualification, as you might have already understood, being in the premise of tort law, going through tort law. Right, now having said that, the fact that we have a few concurrent viewers up and running as well, let's get going with our very first aspect of this particular live session, the Q&A session, by going through a quick outline of the theory of what exactly you need to keep in mind when we look at various aspects of tort law. Fundamentally, when we think about tort law and when we think about the various aspects of this particular subject, by and large, what you need to understand and keep in mind is the fact that it's broken into predominantly two parts. Tort law in general is made up fundamentally of negligence and the various ways in which negligence can occur. So, for example, I often say that tort law is about 60 to 70% negligence, and the remaining 40% is spread across subtopics or topics such as nuisance, the rule in Rylance and Fletcher, occupier's liability, vicarious liability, employer's liability, and so on. Now, even defamation for that matter. Interestingly, the way we need to consider and think of these other topics as being, we need to think of it as being different manifestations of negligence. So our core, our fundamentals of tort law are built upon negligence, and then circumstances in which that takes place would be in those other topics. So for example, if something is said by a party negligently and it's established as such, harming the reputation of another person, that would be coupled within defamation. If someone's negligent actions affect or unreasonably affect the enjoyment or interferes with the enjoyment of the other person's land, that gets coupled into nuisance. If an occupier's negligence leads to either property damage or injury or even death of a person who has permission to be in that property or even a trespasser, falls into the category of occupier's liability. If, for example, the actions of someone under the control or the employment of another goes ahead and does something, there might be extension of that liability vicariously to the employer. So what you'd notice here is that the core element is that of negligence. And negligence in itself accounts for a fairly hefty chunk of this subject, primarily because everything other than negligence, as I noted earlier, is a manifestation of negligence. So when you think about negligence as a topic, you're looking at fundamentally 4 areas, a sequential process, so to speak. Firstly, in relation to duty of care. Does the law impose upon you as the defendant a duty that you owe to the claimant, to the other party? Once that duty is established, the next step is to determine if the person who owed the duty, the defendant, has acted below the reason expected of a person in that capacity. We refer to this as breach. Now, there's a common misconception when it comes to duty of care in relation to negligence, that students believe that duty of care equals negligence. It does not. Duty of care is one part of 4 parts of negligence. It is just our foot through the door, so to speak, in relation to negligence. Once we establish duty, our next step is to determine if, as I mentioned earlier, there has been some sort of breach, whether the person who owed the duty acted below the reasonable standard expected of him or her. Once this is the case, much like how in contract law, consideration is what enforces the contract, it's the badge of enforceability as McKendrick calls it, breach would define the vanguard or the most important component of negligence. Because once you have established a duty and then you have suggested that that duty has breached by virtue of the defendant acting below the reasonable standard, step number 3 would be to assess whether there is causation, whether there is a sufficiently certain link between the actions of the defendant and that which has been suffered by the claimant. Once this is done, step number 4 is remoteness. Remoteness in the context of whether the outcome that has been suffered by the claimant, by the victim in this case, could be considered to not be too remote or unforeseeable. The damage, not the fact that he would affect the claimant, but the actual damage sustained, whether it can be considered to amount to something that is sufficiently considered within the purview of something that is foreseeable by the defendant. Now, by and large, as big as this subject matter is, as nuanced as it is, and as much case law and principles there is to go through, what we must fundamentally remember and keep in mind is that if you know negligence, you've won half of the battle, so to speak. What I mean by that is the whole essence of tort law in general is to first consider the aspects of negligence and then apply the different elements, so to speak, to it. So as I noted earlier, nuisance, for example, amounts to negligence in the context of property, enjoyment of property. Rylance and Fletcher extends that further in relation to damage sustained on property. The same applies to vicarious liability. You're essentially looking at holding liability for someone, controlling the defendant. You're extending it. The principle here is that of the deeper pocket. And finally, you have topics like occupier's liability, for instance. What occupier's liability tends to look at is the liability accrued towards a person who is in control of a particular premises or a vicinity, and what sort of liability will accrue therein. Right. Now, generally speaking, outside of the context of the subject matter that we just looked at, because once again, this is a vast area, you can find more substantive content on this through the YouTube channel, as well as on my online law school platform, which you can check out through the links in the description. But outside of that premise, in terms of the actual way to think about tort law, because it's very important to wrap our heads around the techniques that are necessary to tackle questions and problems that we encounter. And I'm trying to wrap with the context of the fast track theory as much as possible, as quickly as possible rather, because I do see quite a hefty chunk of questions that have come up on the live chat so that we can go through those together. But generally speaking, as an overall outline, essentially, what you need to think about in relation to tort law is that it being positioned between that of the principles of criminal law on the one side and contract law on the other. The reason why I'm saying that is, if you recall, when we did the live Q&A session for criminal law, for instance, criminal law deals with what we like to refer to as a one-to-many relationship. So a one-to-many relationship in the sense that the government or the country stipulates what the laws are. They will suggest an outline that this is what amounts to a crime, and if you break law in this manner, this is the punishment. Similarly, the outcome of being charged and then convicted of a particular crime as prescribed by the law of that country is a punishment. Either you are imprisoned or you have to pay a fine, or both. On the other hand, if we take contract law in terms of its subject matter, it's a one-to-one relationship. It's two or more parties that are agreeing on certain terms which are unambiguous and directed at one another. That contract that is defined leads to, if there are breaches, if one or more parties are not fulfilling the obligations that they should, the outcome of that will be either to cancel or rescind the contract, or to pay damages, or both. But the punishment is not the requirement, it's to put the parties back into the place they were. In criminal law, it's the opposite. It's a one-to-many and it's punishment based. Tort law happens smack in the middle. The reason why I'm saying that is because, much like criminal law, this is a duty and obligation that's imposed on the defendant by the law. It's not something that the parties have agreed to, like in contract law. But much like in contract law, the outcome is in relation to putting the parties as close to the position they were before this incident happened. So the outcome is not a jail term, it's compensation. It is to make sure that the parties are redressed adequately. Right. So that's our fast track to quickly go through tort law, and specifically to look at how exactly we need to think of and argue the subject matter. There's far much more content that you have access to on this channel as well, and the time frame that we have is insufficient to go through everything in detail. But do reach out if you have any specific questions as well. But having said that, let's try to go through some of the questions that were addressed to me on both the YouTube channel prior to this session commencing, as well as the live chat. First, let's have a quick look at the questions that were posed by some of those who saw the notification earlier. So one major question that kept cropping up is in relation to drafting of answers. So to quickly go through that before we go into the live chat, generally speaking, I've mentioned this on several videos on this channel as well. In any problem-based scenario, when you are answering a question, make sure that you have addressed and touched on 3 specific points. 1, show the examiner that you are aware of who the parties are and their relationship to one another. Secondly, show that you have an understanding and a knowledge of the primary and secondary areas of law being examined. And thirdly, make sure that you indicate the fundamental issues that are in question and how best to tackle it. Once you have these 3 points in place, the remainder of your answer is essentially an exposition of it, breaking it down and going through it in detail. That's a very broad stroke idea of how you can answer questions. It will obviously differ based on the type of question that you're answering, the topic, what sort of thing is being focused on, the subject matter, and so on. But generally speaking, that would be the outline. So let's quickly go through the live chat and see what sort of questions we have from the different viewers currently. Okay. So there's quite a hefty bunch. Let me try to get this into a place where it's not cutting into anything else. Okay. Okay, when can the same act be both a tort and a crime? So this is a good question, Raja Lakshmi. Thank you for joining us. So generally speaking, let's take an example like a motor traffic accident. In the UK, you have the Road Traffic Act, 1988, I believe. So generally speaking, you may have been involved in a road traffic accident, which means that it falls under the premise of a criminal offense. And if there is a death, for example, or if there's a serious injury, there'll be certain offenses that accrue to that. Now, when you have a criminal act of that nature, as I mentioned earlier, the outcome is punishment and deterrence. So you won't see the victim get any compensation for that which has happened. So it's the job of the victim or the representative of the victim to file a simultaneous matter in tort in order to claim damages or some sort of compensation to make sure that they or the victim rather gets some sort of redress in terms of hospital expenses and so on. But generally speaking, not every crime leads to a simultaneous tort case, but crimes would usually be one way in which there's an attached tort claim that is connected to it. It need not be, but it's one circumstance. I hope that that answers that question, Raja Lakshmi. Manishka, hello? Yes, hello. What else? What else do we have? You're most welcome, Brandon. I hope that I'm glad rather that these sessions as well as the lessons online have been helpful throughout. Okay, so that's a good question, Shashi. So in terms of actionable per se, if I'm to compare it into another area of law, you can think of it in the context of when it comes to the distinction between mistake and misrepresentation in contract law. So in mistake, what that renders a contract is void, which means it considers that contract as ab initio or as per its inception untenable. It's void. It's invalid. But if you take something like misrepresentation, what it does is it accrues the right to the claimant to act on it. In other words, it makes it voidable. So when we refer to in any circumstance as actionable per se, it gives the option to. So you can think of it as not strict liability, much like in Rylance and Fletcher, but it's a circumstance which activates the opportunity for a claimant to take that process further. There is a bunch, so I hope that clarifies it. Let me try to go through the remainder as well. Okay, I think there are few instances here, few questions in relation to what exactly or how exactly you can set up certain sessions and all of that. There are links in the description below on how you can reach me as well. We can set up a class program. Apart from that, I've launched a brand new online law school platform with comprehensive pre-recorded masterclasses and fast-track programs as well. In terms of the time factor and the situation that most of us are in, that might be one option as well. The links to that is also in the description. Okay, so there's a question from Jovan. Please, can you help me with Rylance and Fletcher case in relation to strict liability and negligence? So two concepts here. Rylance and Fletcher is a very specific case that we use to establish how actions done on the defendant's land have affected in terms of damage on another person's land. So just for the unacquainted, the rule in Rylance and Fletcher is where the occupier of land brings or accumulates onto his land something which is dangerous and for the unnatural use of land which escapes and causes damage to the neighboring property. So how this differs from nuisance is because nuisance relates to the enjoyment of property. But Rylance and Fletcher specifically look at the damage component in itself. There's some sort of damage that has taken place. So it's strict liability because the mindset of the defendant is irrelevant. In general, strict liability means the action itself is sufficient to accrue liability. The chances of it happening is quite remote in that sense, no pun intended, but in terms of accruing that the liability towards the defendant. There is an informative as well as a very quick video of Rylance and Fletcher in the Law Bytes playlist on this channel. Jovan, just have a look at that. It explains the facts of it specifically and how the principle applies in most cases. So we are going to have a session of several sessions that relates to some of these questions in the future. So I'm going to skip ahead to anything specific to tort law. Okay, primary and secondary victims and in relation to economic loss. This is a good question on its own. Thank you, Namatovu. I hope I'm pronouncing your name correctly. It's always fascinating to have students all around the world, primarily the naming itself. I always like to have an understanding of how names and cultures are sort of intertwined in some way. But I do hope I pronounce your name correctly. So a quick overview. Primary and secondary victims relate to two categories of parties that can claim in negligence. A primary victim can be considered as someone who has suffered himself, either in terms of physical harm, death on his own, or was in danger of that happening. It could amount to the person who is suffering the economic loss as well. A secondary victim is someone who was not in any danger. He wasn't directly affected, but has gotten affected either psychologically or in some sort of recognized psychiatric harm. Now, the principle of establishing any claim for a secondary victim is solely on who that person is and where he or she was in relation to that which happened. So, generally speaking, we look at this as Alcock and Chief Constable of South Yorkshire, the nearness and dearness requirement. You look at where the person was in terms of proximity, as well as who that person was in relation to the primary victim, how close. We consider it in the context of concentric circles. So the proximity in terms of emotional relationship to the primary victim, if you take the primary victim as being right in the center. So when it comes to economic loss, the principles are essentially the same. As long as you apply the nearness and dearness components, you can extend liability to a secondary victim as well in relation to the defendant. Anuj, you have to be a bit more specific in which judgment you are speaking of, because if it is in relation to any jurisdiction other than UK, this is not the forum for it. Sure, Rajalakshmi, my pleasure. I hope these sessions, as much as the content that's available online, have been helpful as well. Do we have any other questions here? I suppose not. Let me just quickly have a look at Facebook as well, so that we've covered all our bases. Yes, there's one question on evidence law. Currently, we are, as in my sessions, are not geared towards evidence. Evidence is a very interesting subject as well, so you might not find much content in terms of evidence on this channel, although there are several other subjects that are covered in the Law Simplified program, which you can have access to if you visit the YouTube channel, as well as my online law school platform, which is courses.thelawsimplified.com. Right. So thank you ever so much for joining. I hope that these continued sessions are helpful. Next week, we'll continue with several other topics in relation to trust law, and in the upcoming weeks, we'll be going through property law, jurisprudence, and several other subjects as well. If you visit the Law Simplified channel, you'll be able to have access to the timetable that I released a few weeks ago. But if you do want to reach out for a one-on-one fast track or a masterclass program, do reach out through the links in the description of this YouTube video, of this live stream. As well as you can reach out by other means on the Facebook page as well. But having said that, stay safe, everyone, because it's a very different world and a very different time. I do hope that you are able to continue your studies amicably and without much issue. We have to always keep the mantra that when the going gets tough, the tough get going. But until the next time that we do meet, have fun, stay safe,